The offer letter called it a role adjustment with continued employment. Employment law defined it as constructive dismissal, a forced resignation that qualified as unlawful termination. I've been working as a senior marketing strategist at a tech startup in Portland for 3 years. I managed campaign strategy. I led client relationships. I reported directly to the VP of marketing. The offer letter arrived on March 12th via email. Subject line: updated role, action required. Effective April 1st, your position will transition to marketing coordinator. Compensation will adjust to $52,000 annually. Please sign the attached agreement by March 19th to confirm your acceptance of these updated terms. My current salary was $95,000. The proposed role was 3 levels below my current position. The responsibilities listed were tasks I'd stopped doing 2 years ago. The email stated this was a role adjustment within continued employment. It required my signature to accept. I reviewed my employment contract. Section 4.2. Employer may not unilaterally reduce employees' compensation or responsibilities without employees' written consent. Any such reduction without consent constitutes constructive dismissal under applicable employment law. A forced demotion with a 45% pay cut wasn't a role adjustment. It was constructive dismissal, a termination in everything but name. My name is Brianna. I built marketing strategies for B2B software companies. I analysed market positioning. I developed campaigns that generated qualified leads. I'd grown our pipeline by 180% over 3 years. I'd never received a performance warning or disciplinary action. Now someone wanted me to accept a demotion that employment law classified as unlawful termination. I opened my contract file and started reviewing my legal protections. Section 4.2 of my employment contract was explicit. The employer could not unilaterally reduce my compensation or responsibilities. Any such reduction required my written consent. Without consent, it constituted constructive dismissal. Constructive dismissal was a legal term. It meant making working conditions so intolerable that a reasonable person would feel forced to resign. Courts treated it as wrongful termination. A 45% pay cut combined with a 3-level demotion met that standard clearly. I also reviewed Oregon employment law. The state recognized constructive dismissal claims. If an employer fundamentally altered the terms of employment without consent, the employee could treat it as termination and pursue remedies. Those remedies included severance, unemployment benefits, and potential damages for wrongful termination. The March 12th email asked me to sign an agreement accepting the new terms by March 19th. That gave me 7 days to consent to what employment law classified as unlawful termination. I saved the email and my contract. Then I consulted an employment attorney. The consultation was scheduled for March 14th. I brought my employment contract, the demotion offer, and my performance history. The attorney reviewed everything for 30 minutes. "This is textbook constructive dismissal," she said. "A 45% pay cut and a 3-level demotion are material changes to your employment terms. Can they do this? They can offer it. They cannot force it. Your contract is clear. Unilateral changes to compensation or responsibilities without your consent constitute constructive dismissal. What happens if I don't sign? If you don't sign, they'll likely terminate you. But that termination would be wrongful because they're attempting to circumvent your contractual protections. What should I do? Don't sign. Document everything. If they terminate you for refusing, you have strong grounds for a wrongful termination claim. And if I do sign? You'd be consenting to the changes. That would eliminate your constructive dismissal claim. I thanked the attorney and decided not to sign. I didn't respond to the March 12th email immediately. I just saved it and continued my normal work. 3 days passed. On March 15th, my manager sent a follow-up email. I need your signed agreement for the role adjustment by end of day Friday, March 19th. Please confirm receipt. I responded, I received the March 12th offer, I'm reviewing the terms and will respond by the deadline. That was true. I was reviewing the terms with an attorney. I just didn't mention that part. 2 more days passed. On March 17th, I received a meeting invitation from my manager and the VP of Marketing, scheduled for March 18th. Subject line, Role Transition Discussion. I accepted the meeting and prepared documentation of my performance over 3 years. Campaign results, pipeline growth, client retention metrics. The March 18th meeting was held in a conference room. My manager opened the conversation. We wanted to discuss the role adjustment we sent you last week. Do you have any questions about the new position? Yes. Can you explain why this change is being proposed? The VP of Marketing responded, We're restructuring the marketing organization. We need to redistribute responsibilities to better align with our current needs. What about my current responsibilities? Those will be reassigned to other team members. And the compensation reduction? The new role has a different scope, so the compensation aligns with that level. I made notes but didn't argue. My employment contract specifies that compensation and responsibility changes require my written consent. Are you requesting my consent for these changes? The VP paused. We're offering you continued employment in the adjusted role, which requires my consent per Section 4.2 of my contract. We expect you to accept the role as offered. And if I don't consent? Then we'll need to discuss whether there's a suitable position for you at the company. I documented that statement. It confirmed what the attorney had said. If I didn't sign, they'd terminate me. I'll provide my response by March 19th as requested, I said. The meeting ended. I returned to my desk and updated my attorney on the conversation. She confirmed that the VP's statement about whether there's a suitable position was effectively a termination threat. On March 19th, I sent my response via email. I have reviewed the proposed role adjustment. I do not consent to the changes in compensation and responsibilities as outlined. Per Section 4.2 of my employment contract, such changes require my written consent. I remain available to continue in my current role under existing terms. I copied HR on the email and saved it in 3 locations. The response came from HR within 2 hours. We have received your response. Given your decision not to accept the updated role, we will be scheduling a meeting to discuss next steps. Please hold yourself available for a meeting on March 22nd at 2 p.m. I accepted the meeting invitation and prepared for termination. The March 22nd meeting included my manager, the VP of Marketing, and the HR director. The HR director opened the conversation. You declined the role adjustment we offered. We don't have another senior level position available. We'll be terminating your employment effective March 31st. I made notes. Is this termination for cause? No, it's a position elimination. My position is being eliminated, but my responsibilities are being reassigned to other team members. The HR director hesitated. The organizational structure is changing. So my work will continue, but I won't be doing it. The marketing function is being restructured. I noted the contradiction. They claimed my position was eliminated, but they'd already told me my responsibilities would be reassigned. What severance am I being offered? 2 weeks of pay per company policy for position eliminations. I reviewed my contract. Section 7.1. In the event of termination without cause, employee is entitled to severance equivalent to 1 month of current salary for each year of service, with a minimum of 3 months. I had 3 years of service. That meant 3 months of severance at my current $95,000 salary. My contract specifies 3 months of severance for termination without cause. The HR director reviewed the contract. That provision applies to standard terminations. This is a position elimination. Position elimination is termination without cause. Section 7.1 applies. We'll need to review this with legal counsel. The meeting ended without resolution. I documented the conversation and waited. 3 days later, on March 25th, HR sent an updated termination letter. Your employment will end March 31st. You will receive 2 weeks of severance pay per company policy. Please return all company property by your final day. The letter made no mention of the 3 months specified in my contract. I forwarded it to my attorney. She reviewed it immediately. They're not honoring your contract. You have 2 options: accept the 2 weeks and file a breach of contract claim, or reject their terms and file for wrongful termination based on constructive dismissal. Which is stronger? The constructive dismissal claim. They attempted to force you into a massive pay cut and demotion. When you refused based on your contractual rights, they terminated you. That's retaliation for asserting your contractual protections. What's the process? I'll send them a demand letter outlining your constructive dismissal claim and the remedies you're seeking. If they don't settle, we file a lawsuit. What remedies? Full severance per your contract, damages for wrongful termination, attorney fees, potentially punitive damages if we can show the termination was in bad faith. I authorized her to send the demand letter. The letter went out on March 26th. It outlined the timeline. The March 12th demotion offer, my March 19th refusal based on contractual rights, the March 22nd termination threat, the March 25th termination letter offering inadequate severance. The letter demanded 3 months of severance per my contract, an additional 6 months of salary as damages for constructive dismissal, and coverage of attorney fees. The company's attorney responded on March 29th. They rejected all claims and maintained that the termination was a standard position elimination with appropriate severance. My attorney filed the lawsuit on April 5th. The complaint outlined the constructive dismissal claim. The company had offered a role with 45% less compensation and significantly reduced responsibilities. When I refused based on my contractual right to withhold consent, they terminated my employment and refused to honor the severance provisions in my contract. The company filed a motion to dismiss on April 20th. The motion argued that offering a different role wasn't constructive dismissal and that I had voluntarily declined continued employment. My attorney opposed the motion with extensive documentation, my employment contract specifying that unilateral changes required consent, the case law defining constructive dismissal, the timeline showing termination immediately following my refusal. The motion was denied on May 15th. The judge found sufficient evidence to proceed with the claim. Discovery began in June. My attorney requested all documents related to the restructuring, my performance evaluations, and communications about my role change. The company produced thousands of pages. Among them were internal emails I'd never seen. One email from the VP of Marketing to my manager, dated February 28th. We need to reduce headcount in marketing. If we offer Brianna a coordinator role at half salary, she'll likely quit. That saves us severance. Another from my manager to the VP, dated March 5th. I'll draft the offer letter this week. 2-week deadline should push her to decide quickly. A third from the HR director to the VP, dated March 20th. If she doesn't accept the new role, we terminate for position elimination. Company policy gives us 2 weeks of severance, much cheaper than her contract terms. My attorney added the emails to our evidence file. The emails showed the plan explicitly. Offer an unacceptable role change, hope I'd quit. If I refused, terminate with minimal severance. Avoid the 3 months specified in my contract. That was bad faith termination. It strengthened our claims significantly. The company's attorneys requested mediation in July. We attended mediation on August 12th, 4 months after my termination. The company's opening position was weak. 1 month of severance, mutual non-disparagement, no admission of wrongdoing. My attorney presented our evidence. The contract provision requiring consent for role changes, the emails showing the deliberate plan to force me out, the termination following immediately after my contractual refusal. The mediator caucused with each side separately. After the third caucus, the company's position changed substantially. They offered 6 months of severance, neutral reference, agreement to pay my attorney fees. We negotiated for another 4 hours. The final settlement included 8 months of severance at my original $95,000 salary, full payment of attorney fees, neutral reference, mutual non-disparagement agreement. I signed the settlement on August 12th. The payment was processed within 10 days. I took September off. I've been working without a break for over 3 years. In October, I started interviewing. I had offers from 3 companies within 2 weeks. I accepted a senior marketing strategist position at a larger tech company. The salary was $110,000, 15% higher than my previous role. The contract included clear provisions about role changes and severance. I started in November. 6 months after the demotion offer that had started everything. The work was similar: campaign strategy, pipeline development, client management. But the environment was different. Clear organizational structure, defined processes, employment contracts that were actually honored. A year after the settlement, I was promoted to marketing director. I managed a team of 5 strategists. We developed campaigns for enterprise clients. 2 years later, I was leading marketing strategy for the company's fastest-growing product line. The team had expanded to 12 people. Our pipeline growth was 200% year over year. 3 years after the March 12th demotion offer, I still had all the documentation. The offer letter calling it a role adjustment. My contract specifying that changes required consent. The internal emails showing the plan to force me out with minimal severance. Those documents had proven that what the company called a role adjustment was actually constructive dismissal, an attempt to force resignation without paying contractual severance. The employment attorney had confirmed it. The emails had documented it. The mediator had acknowledged it. The settlement had compensated me for it. Everything after that had been about building a career at companies that understood employment contracts weren't suggestions. They were binding agreements that applied to both parties equally. The VP had thought offering an unacceptable role change would make me quit quietly. The HR director had thought terminating me for position elimination would limit severance to 2 weeks. Neither had accounted for Section 4.2 of my contract, which said unilateral changes required my consent, or Section 7.1, which specified 3 months of severance for termination without cause. Those provisions had been in the contract the whole time. I'd just been the first person who'd actually read them carefully enough to know that refusing a 45% pay cut wasn't resignation. It was exercising contractual rights that they'd agreed to when these hired me. The settlement had reflected that distinction, and the attorney fees clause had ensured that defending my contractual rights hadn't cost me anything, except the 4 months it took for their legal team to realise they documented their bad faith plan in writing.